When a small business has reached the end of its useful economic life, then the usual procedure is to put it into liquidation. The directors can put that into liquidation by a creditor's voluntary liquidation, where they initiate the process and seek to get an insolvency practitioner appointed direct. Alternatively, creditors or themselves can use the court process called a compulsory winding up. The compulsory winding up, once the winding up order is granted by the court, the dealing with the company passes to the official receiver, who's a civil servant. He then, in turn, could seek the appointment of an independent insolvency practitioner by means of a creditors' meeting or a Secretary of State appointment, or he may decide to complete the winding up himself. The costs of a winding up order, with court deposits, official receiver deposits and some professional fees, are probably a minimum of about £3,000, which is not dissimilar to possibly the costs of a creditor's voluntary liquidation for a small scale liquidation. However, the speed at which the process can be undertaken is slower with a compulsory winding up. It's a minimum of 4 weeks and quite often quite a few more, whereas with a creditor's voluntary liquidation that can all be initiated and got underway in a couple of weeks. Similarly, the speed at which it's then dealt with by the official receiver versus the public sector, there can be a difference in timescales. Typically, the compulsory winding up taking longer. And something else probably that directors ought to be aware of is that in terms of perception, it's generally perceived that a responsible director will put his company into creditors' voluntary liquidation and therefore take the appropriate steps at the appropriate time himself. Whereas with a compulsory winding up, the perception, not necessarily always correct, is that the directors haven't taken the right action at the right time, and the situation has been forced upon them by creditors to take out a winding up petition to force them to cease the company to trade. So I think there are sort of connotations and reputational issues around allowing your company to go into creditors' compulsory liquidation as opposed to a creditors' voluntary liquidation.